me for another 6 months. That's our claim. That's our story. Straight up, that's a good pleading for our basic two elements here. Social workers, though, are going to come back with qualified immunity as a defense, absolute immunity as a defense. Okay? If you plead around these immunities in your complaint, what you want to do, because the rules on what you're going to face at some point is something called a summary judgment motion. The rules on summary judgment are that if in your pleading as the plaintiff, you asserted facts to plead around the affirmative defenses that you think are coming, and you know these are coming, you don't think they're coming, you know, then the burden will be on the defendants to come forward with the facts necessary to establish, to meet their burden of proof, actually, as if it were at trial, that the immunity actually is there. So it's important that when you plead your case, and you set it out in your complaint, with regard to, for example, qualified immunity, a social worker will be entitled to qualified immunity if, at the time in question, it was not clear to the social worker, it was not clearly established that their conduct violated your civil rights. Clearly established is the element that catches everybody because it gets really dicey. Now there's a lot of law, and we posted this on the Saga site too, and if it's not there, it will be shortly. I just finished a huge brief on this, so this is very apropos for the moment, actually. Clearly established. There are different ways we can get to clearly establish. The most obvious way that the court will want to rely on and that the defendants will want to rely on is they will come out and they will say that the law, at the time that the defendant did these horrible things, was not well settled. The appellate court hadn't yet decided that it was unconstitutional for me to lie in court reports, for example. That's a good example. You may laugh, but we face this all the time. It seems obvious, right, that it's wrong to lie. You know, I remember getting an ass whipping when I lied about things. And I would assume that social workers got the same ass whipping, but apparently not, because that's a very common argument. They come up and they will say it is not clearly established that you can't lie in these different varying circumstances. Now, until recently, and I'm not sure, how many of you, let me ask this question. I know I was beating up on everybody for asking questions, but I have a question that's going to determine which direction we're going to go. How many of you had your interaction with social workers before 2010? So about half. Everybody after 2010 is a lot easier.
Oh, man.
Because in 2010, the Ninth Circuit Court of Appeals came out with a case called Costanich versus the Washington State Department of Social Services.
What was that?
It's Costanich. If you do a Google search, this on C-O-S-T-A-N-I-C-H.
What?
Yeah.
What?
That's C-O-S.
C-O-S.
T-A, I can't spell it slowly. It's Costanich, same way it sounds. C-O-S-T-A-N. Costanich.
State of Washington?
Yeah, State of Washington Department of Social Services. And if you use Google Scholar, all of this is available on Google Scholar. I don't know if you guys are familiar with that or not. But you can go into Google Scholar, you can look up cases by circuit, by district, by state. It's actually really good. In fact, we have left this at my office, and we probably use Google Scholar maybe a third of the time, even though we have a paid subscription service. It's actually very good for certain things, and I would suggest that if you have questions, that you use that. But anyway, under Costanich, what the Ninth Circuit did is they came out and said, and they did a pretty comprehensive review of all the historical case law leading up to their decision. And what they said finally is that social workers can't lie. That's basically the outflow. In fact, it's one sentence. It says, going forward from today, it's well established that when social workers deceive the courts, in any circumstance, a civil circumstance, criminal circumstance, juvenile dependency circumstance, whatever it is, even for foster parents, if you have a foster care license, they go in and lie about you now. Under Costanich, they can't do it anymore. It is a violation of your 14th Amendment constitutional right. It took them a long time to get to that. What the courts have been doing for the older cases is they have been relying on that language in Costanich that says, going forward from today, to apply qualified immunity and say, look, until Costanich came out, social workers couldn't have possibly known that they weren't allowed to lie about parents. So that's been a little bit of a problem, and you're going to face that for the older cases that where your interactions started before 2010.
I have an issue with that.
Hold on. Where you started before 2010, it's a little bit of a problem, but we've got a solution to it, we think, and actually it's going to be heard coming up on December 6th in Orange County. But basically what the idea is, and I'll let you guys know how it works, I'll know soon enough, but the idea is, under clearly established Ninth Circuit law, we don't have to just look at the law at the time to figure out whether or not we knew we couldn't lie. We can look at training materials. We can look at unpublished decisions. We can look at trial court decisions. We can even rely on, imagine this now, this is a big one, common sense. And there is case law to support it.
Somebody mentioned.
I agree. Common sense makes a big difference. We'll see what the courts think about it. There is case law out there. There's a case called Drummond. There's a case called Nelson. They're both Ninth Circuit cases. And they both say essentially the same thing, is that your right can be so obvious that we don't need to look at case law to figure out that your right was violated. We can just rely on basic common sense. And in our view, common sense is a good argument when you're suing somebody for lying about you to take away your children. So that is sort of a developing area right now, and we'll keep you posted on where that ends up. We should have a decision within the next few weeks. All right. I'm a little out of breath, so we're going to take a 5-minute break.